newly enacted or about to be effective regulations from the Federal Department of Labor concerning, again, this is where the overlap, payment of wages to employees pursuant to statute and regulation. I think it's fair to say that there's a pretty clear rule that's now been articulated vis-a-vis the Massachusetts statute. Again, the Prevailing Wage Act in Massachusetts, in contrast to a new regulation, which I think is to be implemented on October 23rd, just a couple of weeks away, which obviously is untested and is not yet, there's really no clearly articulated rules of the road as I think now for the Massachusetts Prevailing Wage Act. A disclaimer that I have to give is, my role as a presenter, this is not legal advice. It should not be construed as legal advice. If you need legal advice, reach out to Dunham & Hayden. If we can't help you, we will help you find someone who can. I also want to just make clear that we will do our very best to present these issues as we understand them. But labor and employment is not something that is in our normal wheelhouse at Dunham & Hayden. So with those couple of caveats, I will start the presentation to discuss the Metcalf case. So let's see if I can navigate here. Next slide is
at the bottom. You can just use the arrow.
Right. Okay, so I'll be talking about this newly issued decision from the SJC, both Metcalf v. BSC. Happy to see Sean here. I'm sure you've got a lot of history, Sean, so feel free to share with us what you will. Sean is from BSC.
Yeah, it's a little close to the bone, definitely, but yeah, thank you.
I'm sure. Just a little bit of background on this case. It arose from two contracts that were awarded to BSC and its sister entity, professional services consisting of surveying and related engineering to the Massachusetts Department of Transportation. These projects extended over several years. One of them was issued prior to the enactment of this statute, which I mentioned a moment ago, Section 58. The second contract came into play after Section 58 was enacted. The SJC in its decision didn't make a big deal about it. They simply noted that even though the earlier contract was enacted, was put into effect prior to Section 58, the court said, well, the parties proceeded as if it were already in effect. There's really no difference in how they were treated. I don't think that will be an issue for others going forward, but again, it doesn't seem to be a big distinction, at least from the perspective of the SJC in this decision. So under this contract, BSC was by crews of field surveyors to perform services on various public works projects. Were not a particular project. It was not characterized as a public works per se, which is an important term under the Prevailing Wage Act. But these were essentially contracts by which BSC was asked to provide services to DOT on an as-needed basis within a certain region, I think mid-state Worcester area. So plaintiffs in this case are Russell Metcalf and Stephen Thur. One of them, I think, was a field survey crew chief. The other was, I think, just a more of a frontline surveyor. What happened here is the main plaintiff, Russell Metcalf, changed position. BSC went to another firm in which he was earning a higher rate pursuant to the Prevailing Wage Act. And I'm guessing here, but I'm assuming that it occurred to him that, hey, wait a minute, I should have been paid this same wage when I was working for BSC. I'm doing the same work I was doing before. I should be entitled to get those wages. So that led to the filing of this lawsuit on behalf of both gentlemen. they sued BSC for back wages under the prevailing wage act. So just in terms of the setting for this particular decision, there was a number of cases in Massachusetts that had construed the prevailing wage act. There were some inconsistencies and ambiguities, and that makes for a good opportunity for the SJC to look at the conflicting decisions and come up with a rule that will resolve those inconsistencies. And that's basically there's typically once a case goes through the trial court, it would go to the appeals court, but there's a mechanism for the state's highest court, the SJC, to take a case and make a decision on its own. We don't know, but again, I'm guessing here that the SJC did that because there was some ambiguity in what the what the Prevailing Wage Act required. And then we come in, Donovan Hayden came in at the request of ACEC because of the fact that the issues that were in dispute concerned matters that were of concern to ACEC members, not just BSC, no disrespect to you, John, but to many other surveying firms and engineering firms, in fact, who could find themselves in a similar position of being. Just 1 second. Somebody's got to try to bear along here. In any event, Donovan Hayden took on the assignment and Michael and I prepared a so-called amicus curiae brief, friend of the court, in which we made the positions that were important to ACEC members to make sure that they were fully aware of the implications of the questions they were deciding to the industry as a whole.
Just right click.
Hit the
Right.
forward button.
Yeah, or you can just
Arrow buttons on the screen.
Okay. Sorry, folks. There we go. Okay. There are a couple of characteristics of these particular contracts that are important that I wanted to put on the table. First, the contracts were not tied to a specific public works construction project. All of these distinctions are important because they are sort of the hallmarks of a contract that is subject to the Prevailing Wage Act. In this case, they were not tied to a specific contract. They were on-call services, essentially, that BSC was being asked to provide on an as-needed basis. These contracts were not competitively bid. Again, the purpose of the Prevailing Wage Act is to obtain the most conservative, the lowest cost bidder, and it's typically a contract in a public works project is typically awarded to the lowest bidder. But in doing so, the state wants to be sure that these firms are not paying their employees an unfair wage. And so that's why there is a provision under the Prevailing Wage Act for companies bidding on public works projects to pay a prevailing wage to their employees. In this case, these contracts were not competitively bid. And so there was a different sort of lens that the SJC was looking at when it considered whether these contracts should be subject to the Prevailing Wage Act. Third point here, under contracts that are bid under the Prevailing Wage Act, there is actually a schedule of wages that are issued by the Department of Labor pursuant to a request from the agency that's letting the contract. Here, there was no such prevailing wage schedule attached to the contract. And then lastly, unlike the Prevailing Wage Act contract for public works project here, in this case, the question of compensation did not come up until after Mass DOT selected BSC as its preferred provider. So the plaintiffs here are making the argument that, they were doing work that was really no different in any respect from other surveyors who were out in the field working on these projects, providing the same services they were providing. These particular plaintiffs worked on 30 different projects, bridge and railroad roadway construction projects. They were often working hand in hand with the general contractor. They supported those construction operations, and the evidence that was developed at the trial court level showed that the contractors, that was the people who were working for those contractors were paid prevailing wages, even though these particular plaintiffs doing similar work for BSC were not. So they made the argument here that they were being treated differently, meaning that they were paid lower wages, and that was just unfair and inequitable. So this is where section 58 comes in. Again, this is a relatively new statute. I was going to look up exactly when it was enacted, but sometime in the last 5 years. And this statute is a mechanism by which state agencies such as the Mass Department of Transportation can secure professional service firms to provide services on various projects. And it's a fairly broadly defined set of professional services under section 58, including both surveying as well as architectural engineering services. Now, it's important to note that this only applies to state agencies like the Department of Transportation. It's not for public-private partnerships per se or other private entities. Again, it's a fairly broadly worded statute in terms of the types of services that fall within its preview, and the court really looked at the statute and made a determination that, unlike the Prevailing Wage Act, these were sort of these types of services that were bid for under Section 58 for professional services, which again were not tied to any particular public works project, which were in the nature of being on-call services and which required professional services, were a different kind of entity, a different kind of scope of work than was the subject of the Prevailing Wage Act. So, already covered some of these points. Again, the Prevailing Wage Act applies to contracts for the construction of public works. The contracting agency, in this case, it would have been Mass DOT, is required in those type of contracts to submit to the Commissioner of the Department of Labor a list of the jobs that are anticipated to be included in that public works contract. Then the Department of Labor makes a determination of what the prevailing wage is to be for each of those categories of workers, and it issues a schedule that is then attached to the request for proposals that are sent out by whether it's the DOT or some other state agency. And it applies to all of those jobs that are performed on public works project. It includes a list here of mechanics, apprentices, teamsters, chauffeurs, laborers, which is, I would argue, and I think we argued in a brief, our amicus brief, a very different type of labor versus professional service provider, labor versus professional services. The SJC didn't address that argument in its decision, but I think it also helped to define the distinction between the two statutes. So some of the important distinctions that the court made, the SJC, Supreme Judicial Court made in its decision, are again that these types of services, professional services under Section 58, that they, unlike the Prevailing Wage Act type of contract, are based on the qualifications of the provider. And it's not based on any determination of the costs that are to be involved in the selection of that provider. Section 58, unlike the Prevailing Wage Act, doesn't require that the wages to be paid to employees are included in the contract. And as a result, for those reasons and others, the court made the determination that the Massachusetts legislature didn't mean the Prevailing Wage Act and Section 58 to apply to the same contracts that have very different contexts. And they could operate separately, which is what the SJC suggested they should do. There's not necessarily an overlap between the two. And that, I think, is made clear by this quote from the court. Field surveying work performed under a contract for the construction of a public works project requires payment of a prevailing wage, but that work, when performed under a contract for professional services, which again was an issue with the DSC contracts, does not require payment of a prevailing wage. The court also looked at the administrative opinion issued in 2011, I think in connection with the Big Dig. The court noted that in that opinion, there was a distinction between field engineer surveying work performed under a construction contract for public works, which was subject to prevailing wage, and those like at issue here, which were not. The court noted that like the court itself, the Department of Labor, the Massachusetts Department of Labor, did understand and acknowledge that some work, even though it was essentially the same type of work, if it were performed in different regimes, could result in different requirements for the payment of wages. So in this case, the end result is that the plaintiffs were simply not entitled to recover back wages under the Prevailing Wage Act. So a couple of other takeaways here before I turn it over to Paul. Again, the SJC focused on the distinction in the two statutes, the Prevailing Wage Act and Section 58. And it was, it could have, but it didn't necessarily limit the case to the facts presented. In other words, to these contracts for land surveying work. I think the takeaway can be much more broadly construed to other professional service firms, so long as they are providing services under that statute on call on an as-needed basis by the state agency, which again is distinct from a public works contract, a very specific scope of work. So the nature of that type of contract determines which act will apply. And when there is determination that it's a professional services contract being awarded, and again, you should be able to know, because if you see a request for a proposal with an attached schedule of rates, labor rates, you got to be careful that you're not going to assume that you can pay what you want. You've got to comply with those wages that are set forth in the contract. If you're bidding on a contract that does not have that schedule, that's asking for your firms to provide professional services on an as-needed basis, I think you're in pretty safe territory to assume that you're going to be covered by this other statute, Section 58, and not the Prevailing Wage Act. One caveat, there is, I guess, a little bit of unknown aspect of what the SJC, it didn't address, and I think because it didn't have to. There's a prior decision where there was a contract that was issued, what really should have been issued under the Section 58, but did include a provision for the payment of prevailing wages. It would not automatically be taken out of that confine or out of that construct for prevailing wages and put in the construct for Section 58. So there's, I guess, a bit of an open question if the contract is bid with a schedule attached to it that should be a professional services contract, but I don't think a high likelihood that that's going to be an issue that hopefully any of you are going to need to address in the future. Having said that, I think it's a little bit clearer, I think, under the regulations that have just been issued by the Federal Department of Labor under the Davis-Bacon Act. And I'm going to let Michael discuss that. Thank you.
Thanks.
Before we go on and while we're moving equipment here,
Sure.
I just want to point out to everybody that Mass General Law, Chapter 7C, Section 58 is the state QBS law that Massachusetts, that ACC Massachusetts advocated for many years ago to get it into state law. So it mandates that Mass DOT use QBS, which they're supportive of anyway, and need to when for their jobs. But it also has been helpful in negotiations with municipalities. It does not mandate that municipalities use QBS, but it's a strong suggestion. And back over to you.
All right. Thank you, John. As John said, my name is Michael Robertson. I'm on counsel with Dominic Hayden LLP. I'm going to repeat John's admonition to please not take this as legal advice. As John mentioned, labor law is not something that we normally do. We are happy to do this research for ACC. It's been a very good learning experience and hopefully can help everyone moving forward. There is a joke about law school that is 3 years of learning how to say professionally, it depends. and that is really one of the lessons that I think comes out of both Metcalf and the Davis-Bacon Act. So we will try to provide some general guidelines, tell you what the new regulations have said, and then a lot of the answers to your question, maybe it depends. The Davis-Bacon Act applies to workers on contracts only entered into by federal agencies for public buildings or public works. They have to be in excess of $2,000, which is probably a threshold that most of your projects meet. The Supreme Court previously has described the Davis-Bacon Act as a minimum wage law designed for the benefit of construction workers. And on August 23rd, 2023, the Department of Labor published a final rule entitled Updating the Davis-Bacon and Related Act Regulations. These updated regulations issued under the Act set forth new rules for the administration and enforcement of the Davis-Bacon labor standards, again, that only apply to federal and federally assisted construction projects. It may be obvious if a project is a federal project. I can't say how obvious it is if something is a federally assisted construction project. So that's something to be aware of if you're engaged in a project of that nature. These updated rules are scheduled to go into effect October 23rd, 2023. They only apply to contracts entered into after that date, so they don't apply retroactively. The caveat there is that that effective date will only take place if the act is not challenged. And given the state of affairs today politically, it seems likely that there may be a challenge, although to date, I'm not aware of one. Changes to the DBA generally fall into one of three categories. They can expand the scope of the DBA to cover locations and workers not previously covered, which we are going to address in more depth. Changes affecting the way the prevailing wage is calculated and applied, which we think will more apply towards the government and what is being told to you, not something that you will have to affirmatively do. And changes that will increase employers' responsibilities with regard to complying with Davis-Bacon and heighten the consequences of failing to comply. And this is a pretty big distinction between your responsibilities under Massachusetts law, as John was talking under the BSC Metcalf decision, and what Davis-Bacon will require of you. And just to touch back on what John was mentioning about the little bit of conflict that we've seen that wasn't resolved in BSC Metcalf, there is one case that is still standing out there, which John alluded to, where there were previous contracts that called for the Prevailing Wage Act to apply. A subsequent contract between the same parties was entered into that did not include those prevailing wages, and the court determined that the parties were on notice that the Prevailing Wage Act applied, and they had an affirmative duty to seek out those wages and to make sure that they were being implemented. That is somewhat of an outlier of a case, but it's worth noting that it is out there. There are a number of amendments in the DBA update and rule clarifications. The new regulations included explicitly permitting the Wage and Hour Division to adopt state or local prevailing wage rates for both highway and non-highway construction projects. And Article 5.2, which is what we're going to focus on, includes a number of changes, including new definitions for contractor and subcontractor. The definition of subcontractor is any contractor that agrees to perform or be responsible for the part of any project. A really important new updated rule includes a revised definition of a construction site, and specifically what is defined as an off-site part of a project, where a significant portion of the building or work is constructed if the site is dedicated exclusively or nearly so to the performance of a single covered project or contract for a specific period of time. That would be the definition of on-site. Significant portion is further clarified to mean that the term includes one or more portions or modules of the building or work, such as a completed room structure, but does not include prefab components, so components that were not manufactured on site. So again, they are attempting to have a pretty bright line test for what on-site means, but they hedge somewhat with this significant portion, which I'm sure will be the subject of litigation in the future. John, can I see your?
Sure.
Yeah.
Yeah.
So again, focusing on Article 5.2, and this is really the part that BSCV Metcalf focused on as well. When discussing what a laborer or mechanic is for the purpose of determining whether or not the Davis-Bacon Act applies, the new updated rule clarifies that when you're considering a survey crew member who performs primarily physical or manual duties, it's important to consider and appropriate to consider the importance of the worker's different duties, including time spent on them. For example, a survey crew who spent most of their time on a covered project taking or assisting in taking measurements would likely be deemed a laborer or mechanic. If the work meets other required criteria, for example, is performed on the site of the work and immediately prior to or during construction in support of construction crews, and where employed by contractors, it's going to be covered by the Davis-Bacon labor standards. So what you're really looking at is the nature of the work, similar to the Metcalf decision, and where it is performed. Specifically, that it is, if you're thinking that it's labor on site at the project, it's going to be covered. The current regulatory definition of site of work prior to before the effective date of the update includes a site away from the location where the building or work will remain, where a significant portion of the building or work is constructed at the site, provided the site is established specifically for the performance of the contract for the work. This slide really goes over the definition of the term laborer or mechanic. There's a reference to the Fair Labor Standard Act regulations that provide tests for exemptions from minimum wage and overtime mechanic. I won't go through it too much here, but it really helps drill down on the distinction between a laborer or mechanic who is going to perform manual or physical labor using tools in the trade, as distinguished from kind of mental or managerial work, which we can talk a little bit more. But again, the focus is going to be on those contractors who are performing physical work in the field. The current requirements when it comes to record keeping, which is another important change in the Davis-Bacon Act, include that contractors are required to maintain basic records, which includes payroll, certified payroll, and additional records related to fringe benefits and apprenticeship. However, in the updated rule, there's a clarification in the distinction between regular payrolls and quote other basic records that contractors must make and maintain, and the certified payroll documents and statements of compliance that must be submitted weekly. We have a little outside noise, sorry if you can hear that on the Zoom. The new requirement states that contractors and their subcontractors must maintain DBA contracts and related documents, as well as worker telephone numbers and email addresses. These required records must be maintained for at least 3 years after all project work is completed. So just a ministerial change that could affect your work, and it's important to make sure that you're keeping all those records that you are supposed to. There are also new flow down requirements that are in 5.5A6 of the DBA. Upper tier contractors, in addition to prime contractors, may be liable for your subcontractors' violations. So it is really important to make sure that not only are you following the new Act updates and making sure that you're in compliance, but that your subcontractors are as well. Prime contractors and upper tier subcontractors are required to pay back pages on behalf of their lower tier subs. This is in the case of violations of the Act. So if it, and which I think we'll talk about in a bit, that can be retroactive as well. So there is a distinct penalty if there are lower tier sub violations, which could subject you to not just financial penalties, but potentially debarment in certain extreme circumstances. And this is a penalty regardless of intent. Or it could be that you simply did not think that the Act applied to you and made a good faith determination and did not pay the required wages. It's immaterial for determining whether or not there'll be a penalty. Certainly in terms of the back wages. Upper tier sub, and that applies for prime contractors. However, for upper tier subcontractors, there must be some degree of intent. For example, recklessness to be held liable for the back wages of their subcontractors. In terms of determining what the prevailing wage is going to be, there is a 3-step method. There are some carve-outs and exceptions, but generally speaking, the Department of Labor will follow these 3 steps. The first being that the wage paid to the majority, more than 50% of the laborers or mechanics for similar projects in the area of the construction project in question. If the same wage is not paid to majority of those employed in classification, they go to the 30% of those employed. And if no wage rate is paid to 30% or more of those employed, the prevailing wage will be the average of the wages paid to those employed in the classification, weighted by the total employed in that classification. So what are the implications of these updates as it pertains to you? The Davis-Bacon Act coverage does not apply to activities that are independent of the particular contract in question or the project, in keeping with well-established Department of Labor principles, otherwise known as the site of work principle. The Department of Labor maintains that the site of work includes locations where significant portions of a public work or building are constructed. If the contract is entered into and the administrator subsequently determines the correct wage was not incorporated, the resulting effect is that the agency has to either terminate the contract and then resolicit it, or it can issue a change order with the contractor. It's important to note that the proper wage does apply retroactively, and increases in wages resulting from improper wage determination must be paid by the contractor. The Department of Labor does issue back pay to the actual contractor who has to make up the wage gap. But it is something to consider that if it is determined that the correct wage was not initially incorporated, you will be liable for making up the difference in the first instance and then being compensated by the Department of Labor, which could have an impact on cash flow and other activities. And again, the Davis-Bacon Act does not extend to activities independent of the project. Specifically regarding survey crew members, the Department of Labor has reiterated that whether a specific survey crew member is covered by the Davis-Bacon labor standards is a question of fact based largely on the actual duties performed. And this is where my "it depends" admonition really comes into play. While there are no additional changes to the definition of survey crews, there is an important clarification that survey crew members who spend most of their time on a covered project taking or assisting in taking measurements would likely be deemed laborers or mechanics, provided they are not exempt employees. When you're looking at whether or not a survey crew actually performs primary physical and or manual duties, you have to consider the importance of the worker's different duties, including but not limited to time spent on those activities. And if the work meets the required criteria, the site of work where required, if the work is performed immediately prior to or during construction in support of construction crews, odds are it's going to be covered by the Davis-Bacon labor standards. So this harkens back to the record keeping question. Not only do you have to make sure that you're keeping the certified payroll records as are required, it's really important to make sure that you're keeping track of the time that individual survey members are spending on these physical labor activities that will implicate Davis-Bacon standards. As a general rule of thumb, when you're trying to determine whether or not a survey crew member is going to be subjected to the new updated standards, you want to consider a few certain factors. For example, if their work is performed on site, keeping in mind that the Act has revised and clarified what exactly doing work on site means. The construction is performed immediately prior to or during construction. So you can't just conceive of the construction project as when actual construction is beginning on site. If the survey work is done to help prep the site, that's going to make these crew members subject to the fair wage. If the work is performed in direct support of construction crews, and if the duties are manual or physical in nature and include the use of tools or work of the trade. So it's a really simple way of thinking about it, but if you're doing physical work in the field that requires tools versus sitting at a desk thinking about people that are doing physical work and using tools in the field, that's a good way of distinguishing between the contractors that are subject to or are not subject to the wage. Surveyors may otherwise be exempt if they are considered learned professionals, depending on licensure requirements. And this is one of the distinctions that was talked about in the Metcalf decision, where employees that have the same title can be subject to the prevailing wage depending on what they are actually doing. So again, sorry to keep repeating myself, but it is the physical nature of the work that can really be a test of whether or not the Davis-Bacon Act is going to apply. To qualify as a learned professional, one must have an advanced type of knowledge gained through a prolonged course of specialized intellectual instruction and study, which translates to specialized academic training. Experience and on-the-job training, apprenticeships are not enough to qualify, but survey workers who work under the supervision of a licensed individual or learned professional are still covered by the Davis-Bacon Act if they perform covered work. So a survey worker who is contracted by an engineer who is performing physical labor in the field with their tools would be covered under the act. So I just wanted to note here, sorry to back up a little. There are a few court decisions that John and I found in the course of researching the amicus brief for the Metcalf decision that I just wanted to touch on because they discuss whether or not somebody is performing work that could be considered a professional service or more physical labor in nature. There was a 1991 Mass Appeals Court case that found that if you're trying to determine whether or not an activity falls within the scope of a professional services exclusion, this is in the context of insurance coverage, courts generally look to the nature of the conduct under scrutiny rather than to the title or position of those involved. The salient question to determine whether or not something is a quote, professional service is whether an occupation requires specialized knowledge and mental skills rather than physical skills. So for example, if John and I somehow found ourselves employed as surveyors on a project doing land survey work, it wouldn't matter that our title is attorney. It would depend on the work that we're actually performing in the field. Not that I think anybody would want to hire either of us to do that work. Certainly not me.
There are a bunch of professional land surveyors on this call who are desperately looking for people to be on survey. So I wouldn't roll it out.
No, I could use a side hustle. There's a 2008 Mass Superior Court that determined that the focus is whether an occupation requires specialized knowledge and calls for mental or physical skills. A 1968 Nebraska decision found that a professional act or service is one arising out of a vocation, calling, occupation, or employment involving specialized skill, labor, or and I would just note that according to the Mass Association of Land Surveyors and Civil Engineers, most of you probably know this much better than I do, the first step towards becoming a surveyor is earning a degree in surveying or geomatics. It can be a 2 or 4 year degree. Then there's a fundamentals exam, then work experience and the supervision of a licensed professional land surveyor, and then a national exam and a state specific exam. So there's a lot of intellectual and academic work that goes into becoming a surveyor that would lead to them being described as providing a professional service. Again, there's this distinction between Massachusetts law and the Davis-Bacon Act, the federal law, which essentially provides that even contracts that do not explicitly include the Davis-Bacon required language are deemed to have been incorporated afterwards by virtue of the requirement. So as I mentioned before, if it is not included initially in the contract, it will either be rebid or back wages will have to be paid. The final rule, effective October 23rd, confirms the prior understanding that prime contractors, and by extension their subs, must be compensated for increases in wages that result from the accidental omission of the clauses. And as I talked about earlier, prime contractors are responsible for paying applicable wages on all subcontracts. Effectively, you're advancing the excess payments and then you receive compensation from the agency via a modification. So I think that the major implication coming from that is if you are in doubt whether or not the Davis-Bacon Act should apply, or you are bidding on a contract where it appears that it otherwise should, it is always best to ask the question because it'll likely come up eventually, and at least then you know at the front end of the project that you're going to have to pay these increased wages. As a contractor, you should assess the increase in costs and financial implications for solicitation for bid in light of the changes and updates and clarifications to the regulations, there may be a material impact in your pricing strategy for federal projects that would not have been covered prior to the updates, but are now. And you should certainly be aware, as I've tried to emphasize, of the robust enforcement mechanism under the Davis-Bacon Act, including stricter penalties. I see there's a raised hand from Paul Foley.
Thank you very much for putting on this this information for us. I wanted to get a couple of questions in before we run out of time. So two major questions here. Why, if there's already determined prevailing wages in the Commonwealth of Mass that actually covers field engineers, that is the scope of work that is done. If you were to do it county by county in Massachusetts, you would have a specific field engineer rate, and that's what people will be paid. Why isn't that adopted in place of the Davis-Bacon Act? And then the second part of that is that, okay, so we have to adopt the Davis-Bacon Act. Who determines the rate that our people have to get paid? Because I don't know if I've got somebody working in the field, what level of laborer they are. I've got a 2-person field crew, one who's a supervisor, one who reports to that supervisor. Is it incumbent upon me to figure out that wage I'm supposed to pay them?
Both good questions. I should have mentioned, and it's not something that I'm terribly familiar with, but I know that there is a provision in the updated Davis-Bacon Act that does allow for state set wages to be used as the fair wage for a federal project. So there is a process for that, and there is a possibility that the two could be the same. So the Massachusetts prevailing wage could be the wage that is paid on the federal project. There are circumstances under which that will be the case, but it's not beyond the realm of possibility. I think that the answer to your second question is that it is your responsibility, once you know that prevailing wages must be paid to certain employees and certain contractors, to determine which of those contractors it applies to. So you will have the wage set by the Department of Labor, but it is your responsibility to make sure that anybody performing work that would be subject to those wages, you're keeping track of their time as such.
Paul, just to build on that a little bit, as I'm listening to this today, I realize that we need to brief the new general counsel of MassDOT, who is somebody we've known for years, so that he came in from Foley Hoag into state government, and he had formerly been in state government years ago. But we will brief him on this to make him aware, and he will then probably reach out to the State Department of Labor on this.
Sean has a question.
Sean?
Yeah, probably just kind of building a little on what Abby's kind of getting at, I think, because from our side, from the Metcalf case, focused largely on the contracting of those projects and of that, and the work we were doing for MassDOT. Davis-Bacon, the updates as I see them, don't really acknowledge that at all. They're just talking about the type of work that is being done. And Metcalf and Thur made the case that, you know, they were on site during all this construction, and I'm sure there were times that the work that they were doing was advancing the construction. Obviously, we were working for DOT. We were an agent of DOT. So that's the case that we made, that the court ultimately affirmed. But as I kind of read through this and listen to what everybody's saying here, I would think that the case could be made that all of that S1 work that's being done for MassDOT right now could be, Davis-Bacon could be applied to that, and probably might be applied to that. So I think getting that feedback, like you're talking about, Abby, from DOT is kind of critical right away on this. I'd be curious to hear what you guys have to think about that.
After this.
Sean, I would agree with your interpretation. I think that we benefited in that decision from the court focusing really almost exclusively on the nature of the contracts and what those contracts required, because I think otherwise there was a pretty reasonable argument that the work being performed in the field would otherwise be covered.
Yeah, and just building on that, I mean, the SJC in its decision actually said that there's no look back here. You need to look at the contract when it was put out to bid. You can't come in later and say, oh, it should have been that, it should have been this. That would just create too much confusion.
And the court does say, two people doing the exact same work in the field, one may be covered, one may not be, depending on what contract they're doing it under.
Great questions.
Thank you.
If Abby did mention, we will provide this presentation in a PDF form to everybody who would like it. I essentially got through most of it. We just had some best practice suggestions, which I think we've really covered through these questions, but really be aware of your record keeping, because again, you'll be liable on the back end regardless, and better record keeping just helps you in the end in determining who deserves that back pay and who might.
Quick question on my part. Based off the definition of labor mechanic, wouldn't some of the CMTs firms fall under this guidance because they have to be on site collecting and using material to collect the samples to test them?
Acronym CMT.
Construction material testing.
Okay. At least from the perspective of whether the Prevailing Wage Act would apply, you really need to go back to what the contract is, what was bid.
Right.
Was there a schedule attached to it? Or is it for on-call services that an agency is requiring that a firm provide over time? That's not specific to a public works project.
Got it. So that's where you really got to define it.
Yeah.
But I could see a loophole right there where they can get caught up in this too.
Yeah.
Do we have any other questions? Well, I want to thank our Donovan Hayden colleagues for joining this presentation.
Teresa, you read my mind. When speaking with Donovan, when speaking with MassDOT, please request clarification on surveying is occurring as part of a design build project, or the survey is early on in the project to assist with advancing design and survey work would then be utilized by the contractor for construction activities. Yeah, that's a good one, and I don't know how it's going to apply yet, but we will bring it up.
And just a quick take, everything that I've seen discusses that survey work in terms of advancing the construction on the project. So I think it's an interesting distinction if it is done to advance the design versus the actual on-site work of the project. So again, it depends.
That's the takeaway.
That is the takeaway.
Do we have any other questions from the group? Well, appreciate everyone joining today. Abby, thank you for allowing us to present and sign the trust. Yes, Besmir joined us. Thanks, Besmir, for joining us as well. Appreciate the work Donovan Hayden has put into this. And we'll be sending out this presentation later, and the recording will also be posted in ACEC Mass. Is that correct?
Yes, we will send a link to it.
All right. Well, everyone have a great day. Thank you again, and we'll talk soon.
Thank you.
Thank you, everyone.
Thank you.